Donc merci beaucoup aux organisateurs pour.
Thank you very much to the organizers for inviting me, and thank you for this very good initiative. The European Union and the European Commission have a word to say, of course, because this is a question that has come to a lot of member states. Within French law and within the law of different member states of the European Union, there is the autonomy of companies and the fact that the rights are depend on the states therein. Of course, this autonomy of companies have a lot of advantages, because some people will invest in companies because they know that their responsibilities will be limited to a certain area. But this is not matching the modern economy, because we have big groups, we have big companies and companies which are networks. So there is, on the one hand, there's law with the autonomy, legal autonomy of companies, and then we have the reality. And those who are against the law of duty of care would say it is not linked, it doesn't match the real world, but that's not the case. Mr. Rubier, which is a French lawyer, says that law has too much responsibility, and that's a link we make in France, but this also is the case at the European level. At the European Union has to realize that code of conducts are not sufficient because they're not big enough. They don't go far enough because they might apply it only to the rights of employees in the mother companies or of their subsidiary, but only for the subsidiaries which the companies own 50% of. And the code of conduct actually don't take into consideration the companies or the subsidiaries which are not directly controlled by the mother company. So you might have an employee that said, well, we have an agreement here, yes, but the company you're part of is controlled by the mother company. You're not a full subsidiary, and the report says only the subsidiary provides protection, so they don't have the right to protection. And then you have the Samsung case. So there's a company that disregards the commitments it has taken in its code of conduct. Some people say there was unfair commercial trade practices. People say that that might be a reason to sanction companies, and that maybe the due diligence might not be needed. We might not need to impose it at the European Union level, but that's not true. It's totally insufficient. What exists is totally inefficient. Samsung's code of conduct says that all employees are concerned, all subsidiaries are concerned, and if this is appropriate, and there's of course a margin for the company there, if appropriate, some parts of it can be recommended for implementation by some trade partners or affiliated companies. Affiliated companies, it doesn't mean anything in French law, and trade partners, external trade partners that has no legal value, and so it has no consequences for companies such as Samsung. But if we create a law, if there's a disregard for the law, there's a court that's going to judge, but if it's a code of conduct, the court is not competent to judge here. Thank you very much. And if I may ask you a second question, do you think, Nicolas, that the fact that there's no fine in French law right now will make it difficult to implement? I wanted to talk to you about that later, but I can answer very quickly. No, I think that's not the case. I think some media have been a bit too quick to react on this. Some media, not all of them, try to find a way to make the reports interesting for people, and sometimes they say some things that are not the truth. And it's true that the fact that we won't have fine will have some impact, but that the text of law, that the bill remains very strong indeed. The law still exists, the basis still exists, it will grow, and it's a very good law according to me. Thank you.